Viewers, welcome to the Personal Injury Law Show. This show talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me today, I've got a partner in a law firm in transport accidents, Tom Maffia. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And a senior lawyer from Slater and Gordon in Public Liability, Tara Stark. Good evening, Tara.
Good evening, Tony. Good evening, viewers.
Viewers, tonight we've got a very interesting and important episode about public liability and what you should watch out for.
Yeah, Tony, I want to welcome, of course, Tara. Now, Tara's been nominated for Emerging Lawyer of the Year, which the award's coming up in the next couple of weeks from the Law Institute Victoria. So good luck, Tara.
Thank you.
Good luck, Tara.
Thank you very much.
I'm sure you'll win, and we'll
Thank
announce
you.
it in the next episode.
So, Tara, let's talk about what's in the news now.
Well, Don, we've spoken about this Apex gang and how their burglaries and car thefts and whatever. Importantly, what they've done lately is they're breaking into people's houses, taking keys and stealing cars. I heard a story that our premiums for insurance next year are going to go up significantly because of the amount of cars being stolen in this state.
Yeah, and
Isn't that alarming?
they're picking luxury cars, Tony. So
I find that astounding.
Staking out your house, seeing they've got a nice car. And the interesting thing is, you hear that a lot of people have garages, but they don't put their cars in the garage. They leave the cars out.
It's
so it's just an
outrageous.
invitation. So yeah, look, unfortunately, it means the insurance premiums going up, and we're all being penalised for it.
Exactly. And Tara, just, amazingly, this gang of youths are getting caught with the same offences all the time, and they're very violent crimes. You've got kidnappings, bashings.
Yeah, they're pretty scary.
And the fact of the matter is they're bailing them out. I find it extraordinary. Instead of keeping them in remand, they're actually being bailed out.
Yeah, look, certainly it's the sort of thing that you wouldn't want to come across on a late night. I've heard stories of people in cars sort of being hijacked. It's really quite scary.
It is. It's just amazing. And Don, recently they stole a Porsche, and the police, with their no chasing policy, whatever they call it,
Couldn't chase.
let it go. Apparently they then caught up with an elderly Chinese couple and they bolted them up and they badly damaged their hands and arms, and I find it extraordinary. Don't
It
you?
is, and
Yeah.
unfortunately, they're teenagers too, Tony.
Exactly.
Yeah.
So they're teenagers. So how do you, put them away
Rehabilitation.
or try to reform them or rehabilitate them? So, look, Tony, unfortunately, it's escalating, and and we've been penalised with the insurances and all those things.
I don't know. I think they need a good dose of discipline. But anyway, we'll take it up in the future. Tara, Nurofen makers being fined for misleading and deceptive conduct. Tell
They
us a bit
have.
more about this story.
So Nurofen released a range of products which was pain specific. So they had a range of products suggesting that they could target migraines, period pain, muscular pain. The ACCC brought an action against Nurofen for misleading and deceptive conduct, and the federal court did find that the packaging was deceptive because ultimately they have the same active ingredients and the same effect as any other Nurofen tablet. Interestingly, though, the defence for Nurofen had suggested that no rational person would believe that these were actually different products, but I think the consumers would feel quite differently about that. Personally speaking, I think that there would be reason to believe that if they said it was better for migraines than ordinary Nurofen, then you'd believe it, that there might be some difference in the ingredients and the actions. So $1.7 million fine. So federal
It's pretty
court did.
hefty.
It is
But
pretty
it's a
hefty.
massive company.
It is, and in fact, the ACCC did ask that $6 million be fined, but because no harm had occurred sort of to somebody personally, it was purely 1.6 the court found was reasonable.
Well, Don, does this prove that what I've always said, that if you give someone Smarties, they'll think that they're taking something and it might help them get better?
I think that's the case. And it's just the difference was just the packaging.
Yeah.
So years ago, then you said a whole shelf of Nurofen, different type, and it was just the same ingredient. So look, $1.7 million, probably for a big company like that, it's just pocket change. But of course, at the same time, it can also deter other companies or even the same company doing these type of things.
Now, there's this absolute anger directed at Catholic Church because the priest in charge of the Ballarat Archdiocese, which was Mol Kearns, they're going to hold a service for him, Don.
Yeah.
And the Ballarat parish was probably one of the biggest offending churches for child molestation.
Yeah, there's hundreds of cases that's come out from there. I think it's very poor taste in these circumstances. Particularly, we also have the Royal Commission still on foot on abuse. It's inexplicable as to why they'll do that at this stage or any time.
Tara, do you think it's appropriate that they hold such a big service for the priest that was in charge of the parish?
No, look, I did actually happen to see a movie on the weekend. It was called Spotlight. It was about the uncovering of the extent of this sort of abuse in Boston. There was a really powerful quote saying it takes a village to raise a child, but it also takes a village to abuse a child.
Okay.
And I think it's really important that we recognise the role that the broader community plays in ensuring that whenever any potential abuse comes to light, that it's investigated, it's reported to police, and that these offenders are taken away from situations where abuse can occur. So I just think it's entirely inappropriate.
Look, there was a quote here, Don, that says, "It seems totally at odds with a supposed victim-centred response and seems a mockery of the thousands of ribbons tied to the cathedral's fence in support of victims."
Yeah. And just a Tara's point, that movie, which is a great movie, Spotlight, that was based in America. And it's just interesting, exactly what went on back then is exactly what we're experiencing at the moment with these all cover-ups and with the abuse, the extent of the abuse. And I think the last scenes had lists of all the places which all these abuse have occurred. And it just at the end, the screens just rolled and rolled in. Australia had a few suburbs and regional centres up on that screen. So it's a worry.
Lawyers are eyeing a forward class action. More to the point, this is a story about cars where the gearboxes slip.
Yep.
They've got problems with steering. The car assumes its own direction. It's pretty alarming, isn't it, Pat?
Yeah, look, there's been some suggestion and allegation that they slip, they buck, and that they harshly engage. So the lawyers here are suggesting that people are coming back to the dealership as many as 10 times to try and get these cars fixed. So hopefully Ford takes some steps to try and ensure that the cars that are coming out into the future aren't using this transmission.
Don, it's alarming to think that a car has got a mind of its own.
That's right. And Tony, the thing is, we've done this, every show that we do, there's always an article about these manufacturer faults. And it's like coming across every manufacturer, your Ford, your Holdens, your Volkswagens as well. Look, it's a worry, it's dangerous, and it can cause very serious harm.
Oh, yeah, not wrong. Anyway, look, we'll follow this up in due course. What about the young university student who was trying to get back into college? I mean, the gates were closed and he's jumped over the fence and got himself impaled. He got his arm caught in one of those.
Yeah.
It's pretty painful, isn't it?
This isn't the first time it's happened.
That's
but
why I think he's got a claim. Yeah.
I think the court would have something to say about his decision to scale what's clearly a dangerous fence. So I think he'd cop a fair whack for contributory negligence. So his compensation is likely to be quite heavily reduced.
But they don't know why he was there, though.
He's
don't know if it was. It hasn't said. I mean,
well, they've suggested he was from a neighbouring college.
Yeah,
so I'm not quite sure what he might have been up to.
I'm assuming there's a curfew and the gates are closed at a certain time.
Well, it was 1:30 a.m. or something when it happened. Yeah.
And so I guess there's an element of trespasser on the property. And also obvious risk. There's a spiky fence.
Well, it depends on whether, if he's a boarder there, how can he be a trespasser?
He wasn't boarded, he was in the college next.
A neighbouring college.
Arguably he's a boarder. Anyway, I look at it closely because it's not the first time they've been stabbed.
Well, yeah, for that reason, I think there's some suggestion that they might want to do something about the fence.
All right, we're going to go to a sponsors break. Viewers, stay tuned. After the break, we'll start this public liability update. Viewers, welcome back to the show. As I said, we've got a very important episode about an update on public liability. The first case is very interesting because in this day and age, before you can sue for pain and suffering, you need a significant injury, which is a 5% impairment. The cases Santos and Wardren and others, 2009 Victorian Supreme Court decision. Tara, can you give us the facts of this case?
Yeah, so this related to a gentleman named Jose Santos who suffered an injury. He suffered injury to his left knee and right ankle when he had a fall at a shopping centre. The medical panel determined that his injuries didn't satisfy the significant injury threshold, and there were real questions about whether the medical panel had correct reasoning when they were making their decision.
Okay. Now, Don, he didn't get 5% from the medical panel. He was alarmed because he had some pretty significant injuries. And what was it that the Court of Appeal looked at? Sorry, the Supreme Court looked at in what eventually was overturning their decision?
I looked at a number of things. One of the things I looked at is the evidence that was presented and what evidence they considered to come to that 5%. There's a couple of grounds in which the Court of Appeal said that, or the court said that they'll overturn it because the panel failed to take into consideration some significant issues, particularly to do with the diagnosis or even prognosis of the claimant's injuries. So there's a few areas that they've covered. But Tony, this is where, when we talk about the 5% or more than 5%, depending on the injuries, the law has changed recently where it's gone from more than 5 to 5%. Is that correct, Tara?
Yeah, so there was a recent reduction in the significant injury threshold for injuries relating to the spine and also psychological injuries.
Yeah, not across the board.
Not across the
Not
board.
across the board.
Yeah.
Just with civil liability claims for that specific category.
Tara, in this case here, one of the things that were significant before the court was the fact that the line of reasoning didn't sort of follow.
No, it didn't. And there was really quite a glaring error. They referred to the wrong knee when referencing his injury. The medical panel did try to say that it was purely a typographical error, but the court just wasn't convinced.
Well, it didn't follow. I mean, it's not as if it was a slip. When you look at the line of reasoning, they keep referring to the other body part, the other leg.
They do, and they also failed to take into account some x-rays that were before them in the treating specialist report, and they didn't mention why they disagreed with those or really make any reference to them.
There was a lot of gaps, wasn't there?
There were a lot of gaps in the decision.
Don, why would a panel, try and cover up a glaring mistake on their part? Because strictly speaking, they don't know who this person is. What's the explanation? I mean, why don't they just come... Look, there's no harm in just admitting the fact that they've made a mistake.
Yeah. And look, the court had the power to actually call the panel members to court to give evidence, and they didn't do it in this case. Look, Tony, a panel is made up of 3 so-called...
No, there was only 2 on this one, I think.
Or 2.
Yeah.
The conveners of medical panels. And they don't have to... They just go through all the evidence, and they don't have to actually specify what percentage of impairment they allocate. They only say if it's more than 5% or not. Yeah. As simple as that. So you actually can't even follow their lines of reasoning.
So it's a bit of a lottery in some respects,
Well, correct. And for the viewers, when they talk about impairments, an assessment done in accordance with the American Medical Association, and it doesn't look at a person's level of disability, it just looks at the lost function.
And mind you, under those guides, viewers, certain body parts assess better than others, like shoulders, reflux. Psychological generally assesses better than a back.
Well, potentially, but you also have double the threshold. So, 5% versus 10%. So you do need to have really significant ongoing impairments.
One day we're going to do an episode just on how the guides came about, Don, because it was based on the American Army.
Yeah, correct. After the Korean War. And Tony, just look at the evidence. I don't think, just from my understanding of the guides, the reason why it's quite significant is because when the panel assessed it, when they did the assessment, without having regard to full evidence, the decision was probably right, wouldn't have been more than 5%.
Yes.
However, because they failed to take into account particularly arthritis and all these x-rays, that potentially could have got over the line to be over 5%. So it's quite significant for Mr. Santos because it's been referred back, or had been referred back to another panel, another convened panel. I'm
alarmed, Don, that they've made an error which is pretty glaring, I would have thought, Tara.
Yeah.
And they're still trying to justify it. Why don't they just admit the fact that it was a mistake and reseat it person?
Yeah, look, I'm not sure why they decided to defend it in the way that they did. Ultimately, though, for Jose Santos, it did go back to a panel and it would have been constituted by different medical practitioners.
Well, I've got an issue with that too because, Don, I've had 2 reviews from medical panels over the years. The Supreme Court has given me, said, okay, they've quashed the original decision, sent it back to the panels again, and I lost both times. So I don't know.
Unfortunately, Tony, the court's not there to determine whether or not it's over 5% or the 5% threshold. It is really just determine whether or not there's an error of law.
I would have thought that in this one here, the judge could have substituted that decision. I think there was enough evidence there.
Look, just through my knowledge of the guides, the panel was probably right. It just got it wrong, and getting it referred back gives them another shot to get over that 5%.
Yeah, I reckon they got it wrong full stop. Anyway, we'll keep moving. Chandler and Silwood, it's a Queensland decision, 2016. Very interesting case. Can you tell us a bit about it, Tara?
Yeah, so this was a couple that had a child together. The relationship had ended and she had organised to come over to his home to drop their child off. Earlier that day, he'd been hosing down the front of his property. Night was falling and they had a lengthy discussion about her coming over. As she arrives...
Sounds like to me that he set her up.
Well, as she arrives, she slips on the tiles in the alcove in the front door and sustains very significant injury, really, to her right arm. So the court did find that he was negligent.
Can I stop you there? Don, they've broken up. He's got visitation rights. She's dropping a child off. What does he do? He floods the front of her house.
Well, it was earlier on in the day.
He floods the front of her house. There's no sunlight that can actually get to that, so he can't dry it up. There's a bit of algae there as well. He's tried to set her up, I reckon.
It gets even better. He doesn't even turn on the front porch light.
Doesn't turn on the light.
It was
Yes.
8:30 at night. So
This was a dead set setup.
It sounds like a bit of a history there, of course, with the breakup and everything. But in this case, also, she did have 3 glasses of wine.
There was a lot of conjecture about how much she drank,
So
what an impact it would have had.
Gone there, went to step on the step. The first step slips, and she actually cuts her arm, goes through.
Well, Don, there was also an issue about whether she tripped on a step,
correct,
or whether it was going down a step.
Yeah.
It was very confusing, wasn't it?
Yeah, there was a lot of conflicting evidence. In the end, the court decided that she'd had 3 half glasses of wine and that she slipped on the wet surface, but there was certainly a whole range of evidence put forward by different witnesses as well.
Tara and Don, doesn't this highlight the importance of making sure that doctors and lawyers get the facts right? Because one of the things that could have cost this, well, we won't give it a decision yet after the break, what could have been really, really damaging to this plaintiff was the inconsistencies in certain statements, correct?
Yeah, the prior inconsistent statements, and particularly after the incident.
Viewers, stay tuned. After a break, we'll give you the result from the court. Viewers, welcome back to the show. We're talking about this case where this poor lady's fallen down a step or slipped or tripped. That's the thing. See, that's another really important thing I want to raise. Make sure you get your slips, your trips and whatever else correct. Because if the notes at the doctor's clinics or hospitals or ambulance don't correlate with what's really happened, you'll lose your case. Now, in this particular case, there was a lot of inconsistencies about how much she drank, how she fell, all of that, Don.
Yep.
But the thing that worked to her advantage is obviously the judge did like this particular lady and gave her the benefit of the doubt and the evidence that she interpreted in her favour.
Correct.
Also, interestingly, there was a lot of expert evidence in this, wasn't there, Tara?
Yeah, there was. There was expert evidence relating to how certain alcohol consumption might have impaired her. In the end, the court really held that she was unlikely to have been impaired in any way by the alcohol that she'd consumed because they felt that she had only consumed quite a small amount.
Yes. Yeah. And Don, they verbalised that when she fell, where she said, I've been drinking a lot tonight. I mean, she got lucky and the judge accepted the fact that she was in one of those states, in shock and everything else.
And the Good Samaritan came to help her, so this was a neighbour came to help her, said she smelled alcohol. The expert evidence, because the level of alcohol was at 0.057.
There was a lot of conjecture about that.
There was. And the expert said at the end, it'll be because she drank an hour before, it'll be very unlikely that you'll smell alcohol off the breath at the time. Now, the other thing too, Tony, is that the husband, so he's washed down. He says didn't wash down the step, he washed down the wall next to it and would have got some water onto the steps.
Yep.
And he says, of course, one of the things was it never happened before. Now, the court said in these circumstances that the fact that no previous accident had occurred was just a matter of luck.
Yeah, well, that's right.
So it's no excuse. I mean, if it didn't happen before, it doesn't necessarily mean you're not negligent. So you don't have to be on notice.
The other expert they called was an engineer that talked about, did slip tests on the tiles, on the surface, and found that when wet, it was like an ice skating rink.
Yeah.
Whereas if it was dry, she wouldn't have slipped.
Correct. And the importance of that, Tony, I mean, when we talk about other type of cases, a public liability case, like a council case, where they essentially have to be on notice and know that there was a hazard there before the incident happened. When you occupiers liability, that doesn't come into play.
No.
The fact that it never happened before is not a defence.
No. And viewers, this particular plaintiff got a lot of money, but she's got no use of her arm. She got $650,000, but her arm's totally gone. In brief, Tara, tell us a bit about this Kern and Qantas Airways. I mean, it's a bit of a 2015 New South Wales decision. It's a bit of a dog's breakfast, this one.
It is. It's a really unusual pleading. So this gentleman was on a plane from Sydney to Singapore. An engine failed. The pilot did notify passengers that they had 2 functioning engines and that they would be safe to get back to their destination. They turned around and went safely to Singapore. This gentleman's brought a proceeding for compensation and punitive damages as a result of that flight.
Don, interestingly, he'd been to seek legal advice. The law under the Montreal Convention, which sort of puts together all the legislation in relation governing airline travel, you've only got 2 years strict to issue proceedings.
Correct.
This was 4 years later.
Yes. So on that basis, the claim wasn't allowed through. It got dismissed or struck out.
Yeah.
The point, Tony, is when we talk about strict liability, all you need to show is you sustained an injury as a result of an incident. You don't need to show negligence on the part of the
But you do have to show that the accident wasn't your fault.
Correct.
It was caused by a third party.
And the point about Mr. Kern's case is that he actually admits when he went to court that he's got no injury as a result of this incident.
That didn't help.
At all.
Didn't help.
So, but he still claimed a figure of, I'm trying to get so many zeros.
A couple of $1 trillion there.
A couple of trillion, I think it was. So he made a big claim, but he's ended up saying that his claim was based on what he called informed consent or something of the line, where they didn't advise him of the dangers of these engines blowing up before he got on the plane.
This bloke was a little bit too smart in halves. If he had said he had an injury, right, he might have been able to get around the time limits by suing Rolls-Royce, who manufactured the engines.
Yeah, so you've got different time limits for negligence claims, and I think the courts are certainly more likely to allow an extension if you're out of time in that circumstance. But his claim wasn't pleaded in a way that benefited him. And ultimately the court really did have to decide, I think, that he couldn't proceed.
That's an important thing is you should seek legal advice in those circumstances.
We got legal advice.
No, yeah, well, his legal advice, he had no claim and he presented that to the court, so that didn't help his case either.
He's a wannabe professor / lawyer. And
but no, for the viewers, obviously those type of matters, particularly on airplanes, you need to seek legal advice straight away because there are strict time limits that do apply.
Sadly, viewers, he's copped this massive costs order. He's got to pay all 3 defendants' costs, which are going to run into some fair income, hundreds of thousands of dollars, wouldn't you think, Doc?
Yeah.
All right, Nightingale and Blacktown City Council, New South Wales Court of Appeal decision 2015. Quickly the facts, Tara, and it's a very important case, this one, viewers.
It is. So this arose out of somebody sustaining injury after they fell in a depressed part of a footpath. Really, the Court of Appeal looked at the issue of actual knowledge and whether the council had an immunity because they didn't know about the hazard.
Don, in this particular case, there was an inspection of this footpath on a number of occasions, wasn't there?
Yeah, in the past 3 years before the incident, there was actually one was done nearly a month or so, 6 weeks before the incident. And one was a year before and a year before that. So they went out there to inspect it, but they never reported or never picked up that it was a hazardous footpath.
Well, that's pretty hopeless to start off with, isn't it?
Well, it was poor inspection.
Yeah, and guess what? The court's actually...
The court upheld the immunity. So the court read the legislation very strictly. The legislation only allows them to have an immunity in circumstances where they didn't have actual knowledge.
But that's because of the incompetence of the employees of the council.
It is. So the legislation was worded in a way which was very protective of councils and the court upheld it.
Yeah. Don, this is why viewers or people that get injured should get advice from people that are qualified to give it to you. And at the Wiki Carbone, you've got a team of people in Public Liability. And Tara at Slater and Gordon, you work with Don, same office.
We do.
So you can ring us, go to our website or 1300 Injured.
And you need advice very early in the piece, don't you? Because
it is very
there's so many ways of losing these cases.
Yeah, to be able to succeed in a council claim, there's really quite a specific set of circumstances that you need, and it's really important that somebody with the right expertise looks over the inspection and maintenance history.
And viewers, in this case here, the incompetence of the employees of the council actually work to the council's advantage. That's how bizarre the whole system is. So that's why you must get advice very, very early. Don't wait for 2 or 3 years to go by. Speak to these guys, and if you can't get them, give me a ring.
It's an important thing about this case as well is actual knowledge. So pretty much council road authority has to know about that hazard on the road.
It's a very strict interpretation.
But this judgment says, and their honours went on to say that the knowledge must exist at or above the level of the officer responsible for undertaking the repairs. So if you ring up the council, just make council general line, hotline, whatever they want to call it, and make a complaint, they may not be enough.
You're going to have to escalate.
Well, I've got to escalate
Yeah,
it. So the knowledge has to be at that level. So any level below, call centre or anything, bad luck.
That's it.
Yep.
Tara, thank you for coming on board.
No, my pleasure. Thank you for having me.
Don, as usual, thanks for coming on board. Viewers, thanks for watching. Stay tuned for future episodes. Go to our YouTube for past episodes. Go to our social media platforms and always remember to stay safe.